Hello, everyone. My name is Jake House with First Service Residential. Thank you so much for joining us for Ask the Attorney, a very timely topic with all that is going on. I'll be moderating our discussion today. So as we know, during this COVID-19 pandemic, condominium associations are facing new and difficult challenges and uncertainties. I would say that's an understatement. In addition to state laws governing board members and operations at our condominiums, we must now adhere to CDC guidelines and state mandates and local ordinances that seem to change regarding the coronavirus. Accordingly, the goal for all board members is to minimize the risk during this pandemic. So today we'll be covering legal questions you may have concerning three different areas that currently affect your downtown Sarasota condos: association law, construction defect, and land use. So we'll also address how these issues are affected by the pandemic. So before we get started, and Kristen, if I make any mistakes, please wave your hand or say something to me. But before we get started, let's meet our panelists. So Derrick Maginness, an attorney from Norton, Hammersley, Lopez, and Skokos. Derrick, if you could just tell us a little bit about yourself.
Wait, 1 second, Jake, sorry. We wanted to let Eileen, our host, welcome everyone real quick.
Great. Eileen, sorry about that.
Hey,
go ahead.
Not a problem, Jake. Thank you, Kristen. Good evening. I'm Eileen Normile, president of the Downtown Sarasota Condominium Association, and it's my pleasure to welcome all our members, guests, and presenting attorneys to what promises to be an enlightening session of Ask an Attorney. As an attorney myself, I can't think of anyone I'd rather have on my side when a legitimate legal action appears on the horizon in a multi-story, multifamily building than a really good attorney. And as we live through this unprecedented age of pandemic, you can bet there are enough unique legal questions to keep the justice system humming for years. For that reason, DSCA has brought together 3 experts in the field. We thank you all for being with us via Zoom today. While we'd rather all be in the same room, we'll save that pleasure for a time when we can be assured that it's safe for all. In the meantime, ask an attorney. Back to you, Jake.
Thank you, Eileen. So let's go ahead and get started and meet our panelists. Derrick Maginness, attorney at Norton, Hammersley, Lopez, and Skokos. Derrick, if you could tell us a little bit about yourself.
Thank you, I appreciate it. So I'm Derrick Maginness. I'm a partner over at Norton Hammersley. We are a full service law firm, and I kind of specialize in the area of condominiums and homeowners associations. I've been practicing law now for about 11 years. I've been with Norton Hammersley for about 9 of those years. Born and raised in Sarasota, grew up here, 14 years in the military, then moved back here. You know, people ask me, why do I do association work? Really, the answer is because I enjoy watching the board members interact with the members and each other, and that makes it all worth it. So, you know, I'm happy to answer any questions you have. If you have questions that we don't answer today, you know, my contact information is on there, so please feel free to reach out to me.
Thanks, Derrick. Next, we have Erin Christy, attorney at Shumaker. Erin?
Hey there, I'm Erin Christy, and I'm going to be talking about I'll be the land use portion today, and certainly when I have my corporate hat on here at Shumaker, I work on the land use and development team. I started my career in Tallahassee working with Pete Dunbar. Maybe some of you have his book on your shelf. He kind of wrote the law on condo, you know, 718 and 720 on just kind of the condos and statutes and how it all came to existence. And we lobbied together on a lobbying team for the real property probate and trust law section, oftentimes supporting legislation for homeowners associations and condo associations. Nowadays, I find myself more on the developer side. I am married to a board certified condominium association attorney here locally, so you can imagine our pillow talk is real special. And I would say my heart is also in helping people find their, first homes for now homes or forever homes in downtown Sarasota, and love helping people close on properties, especially when, they've talked about wanting to live on Palm Avenue since they first discovered this little heart of Sarasota. So as a native Sarasotan, I do like seeing our community grow in smart ways, and I'm excited to speak to you today about it. Jake, I think you're muted.
Yeah. Next, we have Alan Tannenbaum. Thank you, Erin. Alan, are you muted?
I was muted. Can you hear me now?
Yes.
Good. Okay. Alan Tannenbaum, I'm a construction lawyer. And I'm board certified in construction by the Florida Bar. I've been representing condominium associations now in my 42nd year. And I've been doing it in Sarasota since 1983. So I'm the elder on the panel today. I don't do general association work. Our firm just deals with construction issues on new projects. We assist associations with turnover claims, construction and accounting claims, construction defects and accounting claims. But we also do a lot of work on in building repairs, major repair contracts. We consult, help boards through the repair process. And unfortunately, in projects that don't go well, we get involved in cleaning some of those up after the fact. And that's what we do. Glad to be part of the panel. I'll be mostly dealing today with the repair function and how associations can approach that successfully. Glad to be on the panel.
Awesome. Thank you, Alan, Derrick, Erin, Alan, thank you so much for being on the panel. Just as a reminder, during the discussion, if you have any questions, you may enter those into the chat room, and we'd be happy to get to those questions, time permitting. So we're going to start with Derrick. Let's begin with association legal questions, which seems to be so top of mind as there are so many ever-changing just environmental issues going on right now with associations. So, and the way that COVID-19 has impacted condominium operations. So, emergency powers. What emergency powers does an association have, and how are those relevant to the times today?
So, under the statutes or 718, there's an emergency powers provision. It's 718.1265. Basically what happens is when the governor goes ahead and he issues a state of emergency, then the area that's affected by that state of emergency, the 718.1265 goes into effect. When this first started, there was a lot of questions about whether or not this applied to condos and HOAs, because the real purpose of that statute, when you read it, it seems like it was intended for, tornadoes, hurricanes, natural disasters, and things like that. It doesn't really talk about pandemics or anything, and it talks about damage and those sorts of things. But the DBPR sent out an emergency management order, 2020-04, and basically saying that these emergency powers did apply to associations during this pandemic. Basically what happens is it provides the association emergency powers unless your declaration specifically prohibits these emergency powers. It's in response to an event caused with damage. Florida Statute 252.36 is what provides the governor that power, and really it gives you the opportunity to handle your business in a different way. You can have meetings in locations that aren't where you normally have them. You can provide notice in different manner. You can basically enter into contracts and do things that normally you would have to have a meeting for, that are things that you really have to get to in order to make your business happen when you're not able to. The stuff that those emergency powers kind of projected are not what's happening here. You know, everybody's still at the association. Buildings aren't damaged, roofs aren't falling down. So everybody can still enter these buildings, but you know, your main purpose is to care for the health, safety, and welfare of the association. So, you know, depending on who you are, people don't want to go to meetings. People don't want to meet in person. So you're able to now have these meetings where you can do it via Zoom. You know, you can use the telephonic manner in having the meetings, but if you need to get the meeting notices out to people, you can use email, you can use electronic manners. I don't really know how many people are actually utilizing this stuff because, you know, I live in an HOA. Everything is still posted where it needs to be. Most of the associations that I work with, they're still posting everything where it needs to be posted. They're mailing it out when it needs to be mailed out. But you can look at that and you can utilize those emergency powers to your advantage in order to get your business moving so that there's no delay in getting things done.
While we're on that, could you follow up about just online voting? I mean, clearly we have a regular election coming up in the country, but you know, as folks come back in the fall, it's going to be annual election season, budget season. There's committee meetings going on. Can you talk about online voting and just some proper protocols around conducting an annual meeting, you know, during this pandemic?
So, I mean, it depends on what you're going to do. So if you're utilizing the emergency powers, you're going to probably do things a little bit differently. If you're not utilizing them, then the normal protocols are going to control. And even if you are using those emergency powers, you're still going to have to follow, you know, if you need to mail things out within a certain time, you're going to have to go through that process and do what you need to do. You can give notice in a different way, you know, with the email and things like that. You just want to make sure that everybody's getting what they need to get. And if a mailing is required, that, yeah, you're sending out email if you want to do that, but you're also mailing it if you have to. You can cancel meetings, you can reschedule meetings. You know, if you have an annual meeting that you have to have, but for some reason you're just not comfortable because of the COVID and you don't think that people are safe, you can reschedule those meetings. You know, as long as you give the proper notice. With the online voting, this is kind of a tricky situation because, you know, board members can, when you have a board of directors meeting, that's a little different than when you have a members meeting, right? So the board of directors can basically have their meetings via telephone. You just have to, there needs to be a way for the members to be engaged, whether that's a call-in or a Zoom. I attend my HOA meetings every month. I'm not on the board or anything. I just like to go to listen to what they're going to say, and everybody is allowed to attend it by Zoom. Okay, the board members can vote over the phone because even though you're on the phone, it's as though you're present at the meeting, and it counts towards a quorum. The difference with an annual meeting with members of the association is they cannot attend by phone, they cannot vote by phone, they cannot vote by Zoom. They have to actually show up in person and vote that way unless you have online voting. Now, online voting is different than the board meeting. So member votes are different than board votes. You know, board members, again, they can't vote by email or anything like that, but they can vote if they have a telephonic meeting. Members either have to do it by proxy, online voting, or in person. So if the association is interested in doing online voting, there's actually going to be a great article coming out in the West Florida CII magazine next month that discusses the online voting. And basically the board they have to do a resolution. It has to be approved. It has to go out so everybody has the opportunity. There's certain requirements that you have to meet in order to do the online voting. But the online voting, you know, if you're doing it, it counts towards a quorum. There's just certain protocols that you have to meet, and you have to go through the statute. For our purposes today, it's a lot to go into. If you wanted me to go over that, I would have to go over a lot of stuff. But for the members' meetings, the online voting is allowed. The telephonic voting is not. Whereas with the board meeting, it's exactly the opposite. So, I mean, that's pretty much what I would say about that.
Thanks, Derrick. A lot of projects going on, capital improvement projects. There's a lot of delays just in general with this. So can you talk about maybe an association, I'm just throwing an example out there that maybe had a big project coming, maybe they want to delay it. Can contracts be delayed if it's already in process? Can you kind of talk through that?
Yeah, so this is a tough question to answer without the contract in front of you. I have a hard time believing that anybody had the foresight to foresee this pandemic coming about. So I doubt very seriously that any contracts that were entered into prior to this COVID-19 and the pandemics has any language that specifically addresses delays for a pandemic. I would say generally, no, you cannot delay the contract based upon COVID-19. That being said, there's currently a stream of litigation going on in this state and others where people are, suing for breach of contract or trying to delay contracts or getting declaratory judgment as to what they have to do with these contracts because they're not able to complete the contracts. There are certain legal theories out there like impossibility, impracticability that can be applied. There's force majeure, which some people are claiming that this falls under a force majeure, which is an act of God. I don't know of any courts that have come down, and Alan can correct me because I know he does construction defects, but I haven't seen any rulings come down that the pandemic falls under the force majeure. So you really want to look at the language of your contract. And if you're entering into contracts now, you want to work with your attorney to make sure that you have language in there that if for some reason, as a result of this pandemic, you're unable to meet certain timelines, that there's no penalty or that you can delay it, things like that. But otherwise, I would say no, generally speaking, you cannot delay the contracts. Now, that being said, a lot of these companies are willing to work with people. We've had issues with a lot of associations that I represent where we've gone back to the contractors and said, hey, listen, here's our situation. People are out of town. People aren't traveling. We don't have the proper people in place to get this work done. Can we postpone it? And, they're willing to do addendums and things like that to the contract. So there are ways that you can address these issues after entering the contract. You just have to be very careful because you don't want to be in breach of the contract, thereby, relieving yourself of your rights under the contract and giving them the favorable hand. So it's important that if you have issues, talk to an attorney right away. Don't wait until it's, the deadline to do something. Figure it out beforehand, because it seems like, for lack of a better analysis, the good usually comes out in people when things like this happen. And we've been very lucky and fortunate with the associations that I represent where the contractors will work with us. They will agree to addendums. They will extend timelines and things like that. So you shouldn't put your head in the sand. You should address it right away.
Thanks, Derrick. Rapid fire here. Are condominiums required to waive owner dues for common areas that have been closed? Pools are closing down. Common areas are being closed down due to health concerns and CDC guidelines. Can we waive dues? Can we give money back? What are your thoughts there?
No. I get it. Everybody wants to be nice and help people out, but you cannot waive the dues unless there's something in your documents that specifically gives you that power. Absolutely not. The assessments they're part of the association's annual budget, and they're owed by all owners within the association, right? And that's they're not paying for the use of the pool. They're not paying for the use of the park. They're paying for the maintenance and the upkeep. That's what that money goes towards. And whether it's being used or not, it still has to be kept up. The chlorine still has to be looked at. Everything has to be taken care of, and the maintenance has to be done. Otherwise, it's going to be costlier in the long run, and your dues are going to go up. What the associations can do is maybe choose to implement certain temporary board resolutions to assist struggling owners, maybe waiving late fees, working with people on payment plans, things like that. But you can't really go through and tell people, okay, you don't have to pay when other people have to pay. Because I can tell you, if that happened in my association, I would be upset. I get working with people and doing that, but there's nothing in the law that allows you to waive assessments for struggling homeowners. Okay. you could do deferred payment plans, things like that, but it's going to have to get caught up at some point.
Got it. We have a question, sorry to go back for a second, but emergency power. So from our audience here, when the Florida state of emergency expires, can associations continue to require residents and visitors to follow association authored rules, i.e. wearing masks?
I mean, I guess it's going to depend on what, I know people hate this answer, but it depends on what powers that they have with regards to and how they implemented these rules. If their documents allowed them to implement the rules and regulations concerning the pool, absolutely, you can continue to do that. For me, it's always a question of enforcement. How are you going to enforce somebody not wearing their mask? So if you have a rule, you have to have some sort of way to enforce it, or it's kind of pointless. But you could put that out there, and if people aren't doing it and you have the ability through your declaration, and this is why this is difficult to answer in a vacuum, because every declaration is different. I wish they were all the same. It would make everybody's life easier, but boards only have the power to do what their declaration allows them. So if you're allowed to do that, and generally speaking, as long as you're making a rule that is within the power of your declaration and it's supporting the health, safety, and welfare of that community and the betterment of that community, it's probably going to be held valid.
To create, at the very least, some confusion or agita for the buyer and the title agent. And I see Len nodding his head.
You could just remember to mute. Oh, there we
So
go.
that's my point, Bill.
Okay, thank you.
All right, Derrick. So just some general 2020 legal updates. Pets always seems to come up. So can we enforce our no pet rules at our condominium?
Maybe. There's a lot of condominiums out there that they have the no pet rules, but the Florida FHA can require a reasonable accommodation to a community association's rules, policies, and procedures. One situation is to accommodate a person's physical or mental handicap or disability that substantially impairs the person's major life activities and requires an accommodation. The associations, whether they have a no pet policy or a limited pet policy, they have to go through and they have to look at it and make a reasonable accommodation. If they don't make a reasonable accommodations, then they could be in trouble. So you really have to look at each one on an individual basis. Now, fortunately, Governor DeSantis recently, there was these issues where everybody seemed to have an emotional support squirrel, hamster, whatever. They were, wild boars, things like that. And it was getting kind of out of hand, and people were going online and going to websites where, they would just download a certificate that said, yeah, they need, I'm a doctor and I approve this person as having a disability and they need an emotional support pet. What Governor DeSantis did is he signed Senate Bill 1084, which is now codified as of July 1st of this year under Florida Statute 760.27. And it prohibits discrimination from housing providers to someone require an emotional support animal. But it also prohibits healthcare practitioners from providing information regarding a person's need for an emotional support animal without having personal knowledge. And that's really the key right there of the person's need for the animal. So it became effective on July 1st, 2020, and it requires a patient to establish the need by delivering to the housing provider, which is the association, supporting information from a licensed healthcare practitioner, a telehealth provider, or other similarly licensed practitioners, including an out-of-state practitioner who has provided actual in-person care or services to the patient on at least one occasion. And what this does is it requires them to establish some sort of relationship. So the doctor actually knows this person, they've met with them, they're not just, put your information in and here's your certificate. So hopefully this will, prevent a lot of the people that were just coming out with, I live in a no pet place, but I really want a pet, so I'm going to go say I need this and get the document. But when people come to you, the association, you have to act quickly because there's timelines the FHA puts in there for you to respond. But you have to look at it, and as long as they provide you with the proper documentation, you have to look at it on a case-by-case basis, making a reasonable accommodation. Now, the caveat to that is a reasonable accommodation doesn't mean every accommodation. You know, if you have a pet policy where, you know, you have a 25-pound limit on dogs, and somebody comes in with a 150-pound dog, is that reasonable? You know, maybe not. If they come in with a 40-pound dog, yeah, maybe. So you have to look at each one, okay? So you can't just discard it. You got to address it and make a reasonable accommodation. You should be fine.
So let's move on. Let's get away from pets, right? You probably get tired of talking about pets. So,
I love pets.
but no, I have, well, you know, pets under this circumstance. Love pets. What are the requirements for funding reserves in a condominium? They changed in 2020. What categories are required? What's recommended? What categories are not allowed?
Okay, so basically the board is legally obligated to prepare a budget every year, which includes required reserves for roof replacement, pavement resurfacing, building painting, and any other item of deferred maintenance or capital replacement that exceeds $10,000. The reserves must be fully funded, and the board does not have the legal ability to phase in the full funding of reserves. If the budget with fully funded reserves is going to impose an undue economic burden on the unit owners, the best choice for the board is to call an owners meeting and ask that the owners vote to partially fund the reserves. Or the board, what the board can do is they can call a meeting and have them vote to waive the reserves. You know, but there's certain procedures you have to follow. It's really not that complicated. But if a majority of the owners voting at a meeting approve the partially funded reserve, which could include some phased-in catch-up amounts, that would be legally proper. You really need to look at what you have. I mean, I have some associations where the owners have so much money, they waive the reserves every year. And when it comes time to write that, you know, $20,000 check, nobody bats an eye. And then I have other associations where if, you know, the people living in that condominium had to write a check for a new roof without having reserves, almost every single one of them would be bankrupt. They wouldn't be able to do it. So you really need to look at the reserves that you're having. And the other thing that's important is the only people that can waive the reserves are the people that are benefiting from those reserves. So if you have reserves for, let's say you have, I'm just going to use this as an example, say you have 3 pools. Building A gets to use pool A, building B gets to use pool B, and building C gets to use pool C, but you have reserves for, you know, repairs to the pool, and what building A wants to waive them, but building B does not. Only building A can vote to waive the reserves for the pool refinishing and things like that for pool A, because they're the only ones using that. The other 2 can't vote on that, and like vice versa. So, I mean, that's really all there is to it. It's not that complicated. You know, I personally recommend reserves. I know if my HOA came to me and said, you know, everybody hates that term special assessment, right? So if you don't have reserves, at some point you're going to have to do a special assessment. And if you think being a board member is tough now, bring out the word special assessment and it just gets crazy. So,
Great point. One last rapid fire question. Tropical Depression 14, I believe, is headed towards Florida. Still a long way away. But so emergency plans. Are condominiums required to provide emergency plans? If so,
No.
how often should they update them?
No, there's no requirement. You know, the purpose of this, and this is what's important. The association is there to maintain the health, welfare, and safety, so they should be done. The DBPR highly recommends them, and they put out a great guide. If you go on their website, they have sample plans, and they have a guide that will walk you through what each of your emergency plans should have in it. And you basically just have to take that guide, and you can create your own plan from that. You know, I was looking at it the other day with an association, and it's really a good tool because there's things in there that you're not going to think of. and you can just follow it through kind of like a map. Okay, here's first what we're going to do, what we're going to do. And then that way, everybody, when an emergency does happen, everybody knows what to do. You're not, when the emergency hits, you're not then saying, oh no, what do? We got to do this, we got to do that. You just pull out your little guide and say, okay, here's what we do. First, go do this. Second, go do that. So I highly recommend them, but there's no statutory requirement that they be done.
Great. I think we covered a lot there. Great information, Derrick. Thank you so much. I don't see any questions besides the one that we got to, but if you do have questions, feel free to put those in the question queue and we'll get to as many as we can. Thank you so much, Derrick. So Alan, let's move on to a new topic. We're going to turn it over to you now to discuss building repair and maintenance obligations at our associations. So let's just start it off here. What limitation periods apply to the pursuit of construction defects for condos?
Well, actually, Jake, I'd rather answer a different question.
Perfect.
That was on the old question list. So the question I'd like to answer first is,
Go for it.
Should engineering contracts be reviewed before execution? Groups come to me, they're having a major repair project, and they want me to review the contract between the association and the general contractor. And I say, well, what about the contract between the association and the engineer? We already signed that. Well, if a group comes to me early enough, I tell them that the first thing they should have me look at is the contract between the association and the engineer. Reason being that mostly driven by their insurance companies, engineers have started to place into their contracts general conditions which are very unfavorable to owners, one of which is a limitation of liability. So you may have an engineer with $1 million professional liability policy, but they put in the general conditions that if we're sued and you have a claim against us, our liability is limited to the amount of fees that we were paid for this job, or an arbitrary number like $100,000. You want to take those out. Sometimes they exclude consequential damages from their contracts. Well, consequential damages include, if there's a water intrusion incident, include the damage to the interiors. You don't want to exclude that from the engineer's responsibility, so you got to take that out. You want to put in a prevailing party attorney's fee clauses. So before you enter into that contract with the engineer to do plans and specifications for repair, have that reviewed, and we're available for that. You want me to ask my next question?
I'd say you go ahead and ask your own question.
Okay.
Go for it.
My
Alan
next
knows
question.
best.
I like to ask myself questions. I've been doing that, for decades. Anyway, what are important provisions to insert repair contracts? I give about a 2-hour presentation on this, so I can't cover things, but I'm gonna hit some highlights. Before you even think about entering into a contract, where I've seen groups go wrong time after time, is lack of proper investigation to get to the real source of the problem, so the remedy that's being incorporated into the repair contract is actually going to solve the problem. So I'm a great believer in science, and science says before you enter into a solution that you really diagnose the problem. So that might involve in the roof doing some moisture surveys, or even cutting into the roof to see what the condition underlying it is. If a window's leaking, it may be a window leak, but it also may be a roof leak where the water's coming down the building and that's the path of least resistance. So proper investigation before you even talk about a contract. But in the contracts, again, I'm a great believer in prevailing party attorney's fee clauses. I like owners to be in court and not in arbitration. I like delay damages. because it's your greatest tool for getting your job done on time. You have to check the insurance policies. So what the insurance people are telling me is that some GCL policies, which is what general contractors get, are starting to exclude condo and homeowner associations from the scope of their policies. Or even if they do, they have limitations that are lower than their general policy limits. So one of the things that you must ask in today's 2020 is for a copy of the GCL policy to make sure you don't have one of those exclusions in there. Of course, things like proper supervision. I'm really a great believer in identifying in the contract who are going to be the subcontractors, who are going to be the superintendent on your job. And you can mandate that that be the people that complete your job unless it has owner approval. Every general contractor who does multiple jobs is going to have a variety of superintendents. You know, you want the superintendent who's been with the company for 20 years, not the one that they hired last week. And you can investigate that and mandate. So those are some of the general tips that we would advise.
Good points. So if a condominium, chooses not to repair something or doesn't know how to repair something, how does that affect insurance coverage? So a lack of repairing something in insurance coverage of something and something that you don't know of in terms of, a repair that should take place.
Well, first of all, the obligation to repair is an obligation. It's mandatory for a condo under the Florida Condominium Act. The board of directors, each director has a fiduciary obligation statutorily, as well as a common law. And what people have to remember about condominiums is that there's also a provision of the statute which says an owner can't act on behalf of the association. So you have a unit owner who's getting wet. The board is looking into repairing the common element to stop the leakage. That owner can't hire their own contractor to go out and fix that window or fix the roof or fix the stucco to stop the leakage. They're totally at the mercy of the association. And the association's got a statutory obligation to act. Now, the statute also says that buildings have to be insured up to their replacement value. And what insurance companies do is, if they're prudent, they'll come and inspect the building yearly. But they also require, when you renew, as part of the policy, that application, that you indicate any issues which may raise the exposure risk for the insurance company. So if you don't repair your buildings, number one, the underwriter may come out and say, we're not insuring this building next year because it's too great of a risk because they haven't done repairs. Or you don't repair the building, you don't disclose it to the insurance company, you have a claim, and then they investigate the claim and they find out by getting a copy of your minutes that you knew of problems you didn't act upon, and all of a sudden you have a denial of a claim. So very bad idea to ignore repairs, and it does affect your ability to get insured, and then if you are insured, even to get a claim paid.
Thank you. Repairs going on, lots of construction defect, as always, just in the normal course of business. And then you throw COVID-19 in there. Does that have an impact on getting repairs completed? What are you seeing out there, Alan?
I haven't heard any contractors complain that that because of not being able to get employees out, that they can't complete jobs. So I see repair work being done in the normal course. I think what I've started to hear is a problem in the supply chain on materials. That there's been a more difficult time getting drywall, getting lumber. Some of it may have to do with that there's really so much being built. But I think industry as a whole has kind of pared down their inventories because of the doubt that COVID has brought to the general economy. And So therefore, I think you may have some price rise in projects just because of material shortages. But I don't think it's impacted. What is a problem is if there has to be work done in the building, can you get your contractor to follow appropriate protocols to protect your owners? I mean, there's some roofs that realistically you can't reach other than going up the main elevator of the building to get to the top floor. And I think one of the things I think Derrick indicated, if you're entering into a new contract, it's good to have an addendum that requires a contractor to meet protocols if they're bringing their employees into the building. If they're smart contractors, they'll do that anyway because they don't want their employees getting sick. So, but I haven't seen any huge impact from the COVID. Now, where the industry has been impacted is, there's just some boards that have been delaying projects. Sometimes it's for financial reasons, but I had a board that told me a few months ago, in the face of having some really bad roofs, that we're not going to deal with this until after the COVID is over. And I had to explain to them that there's no exemption to the repair and maintenance responsibility by the fact that there's a national pandemic. There's no, they actually have to act. And it was also the same group. We said, well, we can't meet. And I told them about Zoom and about conference call capabilities. And when I discussed the conference call capability, the president said, with surprise, he was surprised that I could actually do a conference call with all the board members being in their own homes and units. He thought, I said, yeah, that's a brand new technology. We call it a conference call. So it's interesting how some people have dealt with the technology challenges.
Well, we'll be sure to fax them over this presentation when we're complete. Sarasota is exploding. We've got buildings going up all over the place. I think, gosh, there's probably 9 different high rises that are in production. With new ones coming on the market, folks moving in, boards being, put together, talk about newer buildings. What should a board consider, or a homeowner consider, a resident? What should they consider when it comes to construction defects in their new condo?
Well, I did an article recently because it occurred to me that if you compare taking over a condominium to buying a business, there's an interesting distinction. So if you were thinking about buying a business, before you entered into the contract, you would get, if they had a physical plant, you would get it inspected. You would look at the inventory. You certainly would get the financials for the company and make a decision about whether it was a good price, and then you would probably put conditions in the agreement of purchase. A condo transition is backwards. The new board is foisted with this responsibility for operating this business, and sometimes a multi-million-dollar business, but it hasn't been able to do appropriate due diligence. So the due diligence in a condominium transition is like buying a business, except all your due diligence is after the fact, not before. So the reason that you get engineering studies and you review the developer's books and records of association operation, the primary purpose is so that the board has the appropriate information in order to undertake its repair and maintenance and accounting function. And that's where, I don't know how you can operate a building and maintain and repair it if you don't understand how it was put together, what the issues with it may be, and so forth. So that's the main purpose of getting engineering done early and also getting the accounting review. But it also may reveal that there are building defects and financial claims that the developer and other people involved in the development may be responsible for, that should and some claims pursuit should be considered, and that's the type of analysis that we would do at that juncture to determine if there's a viable means of securing recovery. But the key is that repair function is mandatory. Whether a board of directors wants to get into any kind of a claims process is totally a discretionary act, not at all required. But if they're going to consider it, they have to be aware that warranties are limited in time, statute of limitations apply, which is again another reason to get those evaluations done sooner than later.
Thank you, Alan. We appreciate your insight when it comes to construction defect and repair. Just as a reminder, make sure that you submit your questions in the chat box, and we'll get to those as soon as possible. So let's bring in Erin to the conversation. As I was saying with Alan, you know, there's just an explosion in buildings in town, and so land use is such a fascinating area of the law. Erin, we've got, you know, some questions here. Feel free to ask your own questions, but we'll just start out land use wise. How can we minimize traffic and parking issues at our buildings? So we hear a lot of this too. You know, just parking issues at different buildings due to nearby construction. Where do we address this concern? Can you talk about parking with land use and, you know, the explosion in development?
Yeah, and so I'll start by saying I know how plugged in members of DSCA are, and oftentimes I feel when I am speaking to somebody like Patrick or Eileen, sometimes they know more than I do, given all of their years of community involvement. And so I'm going to come at this from practically speaking, under, you know, the purview of the law. You know, what are your options? And so in the big picture, I know we heard last week, or maybe it was the week prior, from FDOT. When you're looking at long range transportation control, you're talking about the planning department, and that's a different, you know, animal. When you're talking about immediate current traffic situation, a light's out, there's a traffic flow issue, in that situation, you're talking to the engineering department of the city. But for these issues where you are dealing with contractors parking in the road, parking across the sidewalk, you're unable to get where you're trying to go, there aren't proper road signs up, things like that. This is pretty heavily regulated in the city of Sarasota by their building department. And anytime you have a new commercial building or even a residence that's over 5,000 square feet, you are required, the owner, and then the contractor, the construction company, is required to file a new construction staging plan. And it's pretty intense if you look at what needs to be filed with the city. There's a narrative where you have to explain all the construction activities that are going to happen and outline the logistics of any offsite parking details, include the proper lease agreement that you would have in order to even be using that parking space, how you're going to shuttle your construction workers back and forth, your contractors back and forth from that parking to, especially in these zero lot line new developments, how are we actually going to get people to the property to do the work? So in addition to that narrative, you also have to file a site staging plan. And the emphasis here for the city is to review that all operations are within the site boundaries, impacts minimized on neighboring properties. There is consistent attention to kind of sediment and debris, dust, and where that's going, the safety of workers and the safety of passersby, like right-of-way preservation and making sure you know where you can go, where you can drive, traffic mitigation, and then, as we talked about, parking regulation. So practically speaking, contractors who are filing this and controlling kind of the day-to-day of how your operations go really want to be that central point of contact when there is an issue that needs to be addressed. So construction workers aren't following the rules. Part of this construction plan is that the team has to submit what they're going to do if somebody from one of their subcontractors doesn't follow the rules. So the contractor construction company really wants to be that point of contact, and I would recommend that a condominium association have also their one point of contact. And as issues come up, make sure you're communicating that to your unit owner. So if that's the manager, if that's the board president, if you have a designated person dealing with that, if everything could flow through one person, and that person is then in turn dealing with the contractor or construction company, that is a better communication. Then at that point, if the construction plan is not being followed and there are still nuisances to your unit owners, then you escalate. I again, practically speaking, you could go straight to the building department, but then you escalate to Larry Murphy's team at the building department to review the plan and address the concerns. These plans have to be updated every 90 days by the contractor. And so they should be up to date as things change, you know, as more and more deliveries are coming and things like that, the plans should be updated. So that was a long way to tell you kind of what should be in place by the contractor and what you should be looking for when you go to address it with him to say, you know, there's no way that you've done this right-of-way preservation correctly. I don't have a sign. I have no idea where I'm supposed to turn. So just think about the things that they're supposed to be addressing in that plan and then make sure that they are.
Yeah, those are great points. And I think what I took away from that was, you know, the single point of contact and making sure the communication's in place between the two parties. So great points there. So picture this, building in downtown has repairs due to a contractor. So, you know, on the building, it's due to nearby construction. What do you do if you're the condo association?
So I'm a little embarrassed to even answer this with Alan on the call. It seems like
Oh, yeah.
I'm happy to
how about this, Alan? I'll give it my best go, and then you jump in and correct everything I say. I will just say this, that typically ongoing construction on a neighbor's property is treated in the context of a nuisance claim. So dust and other particulates that drift over onto an association's property can constitute a form of private nuisance for which the action could lie. And then separately, there's the action to consider of physical damages that are a result of construction, pilings being drilled in, something, you know, more obvious, a crane falling over, things like that, for which the contractor could be liable. Fortunately, contractors are required to carry CGL insurance coverage aimed to cover these damages as a result of the contractor's activities. And I think the long and short of the situation is that a contractor and arguably the owner of the property is who would be liable for this. But please, Alan, fill us in.
No, I like that. That was a good answer. What I would caution is it's a problem of proof. So just because you have a legal theory doesn't mean you're going to be able to prove that the damages resulted from what they did next door. So really, really important is before a project's going to go up close to you is have a very thorough inspection done of your building, let's say by a structural engineer. Document, you know, any cracking or the lack of cracking in the surfaces and so forth. So if there's pile driving nearby, as an example, that you can prove that that's a new crack that just formed in your building, a new piece of stucco that just fell off, you know, windows that you know may have been hit by debris that have cracked and so forth. Otherwise, how are you going to prove that the causation? So that's really important. The other thing you can do is you can be proactive, which is you can contact that developer and say, you know, I'm concerned about my property. What are you doing to protect us? Go beyond what the city's requiring, and you can make, you know, direct contact with them. I won't mention names, but there's a new condo project that's being squeezed in between two existing buildings, and both the owners of the buildings on both sides are very concerned, and they've been very proactive. So that's a good thing to do beforehand.
All right, Alan, I like that. Prove it, as Alan says.
Good. So Erin, short-term rentals or green space? Where do we want to go?
We're gonna go short-term rentals because I can cover that pretty quickly. I think it's a hot topic.
Totally, yeah.
I think we see it less in the immediate downtown area, and where you're seeing this hot topic is out on Lido Key. But essentially the zoning code for the city of Sarasota does outline that residential occupancy must be for a period of longer than 1 week. So essentially any lease must be 8 days or more. And if you violate this rule, you get a code compliance letter demanding that rental cease, and in the event that you have been advertising on Airbnb, VRBO, something like that, usually that violation letter will say something like asking you to stop advertising to reflect appropriate rental periods. I will say that the city of Sarasota checks Airbnb, they check VRBO, they're looking for whether or not you are appropriately reflecting the rental period required in the city. And additionally, I've actually represented a couple clients on these challenges, the Sarasota County property appraiser is also looking at those sites for homestead purposes to see if homes that people are claiming as their homestead are being rented out year round, if they're renting out a room, if they're renting out a space, things like that. So something to keep in mind. I would say downtown condominiums, especially newer ones, there's often rental restrictions that are more restrictive than even that 8-day. So 30-day rentals, no more than twice per year, things like that. So you don't see it that it's less of a daily prevalent issue in downtown condominiums. As I was saying, you know, it's really coming to light and seeing the real issue out on Lido Key, where you've got those mega homes being built, not set up for the condo form of living, so-called house hotels, and the owners are renting individual rooms or the entire house to large groups of people. I mean, upwards of 20 people in one house in the middle of a residential neighborhood. And so I think where you're seeing heated discussion now, really hard, it speaks back to something Derrick said with boards. You only have so much power, and you only have the power for what is in your governing documents. And so the city is coming up against that the zoning code is really not set up to enforce repeat mega rentals in these residential neighborhoods, because once they send their demand letter and ask them to stop and remedy it, the situation's already, you know, corrected itself, and now we're on to a whole new violation of a new rental. And so at this point, the city just really isn't set up to handle or enforce what they're seeing in these code violations of rentals either being short or renting to what would not be considered a family unit. I think one thing that maybe you saw in the news, if you were paying attention earlier this year, is that people were asking, well, why don't you just limit the number of people in a house? And that really comes up against fair housing laws, discrimination. And so city governments especially, or local governments especially, are going to be hesitant to define how many people can live in a home, how many people you can rent to, because you start getting into the definition of family and questions against discrimination. One thing I think we should keep our eye on next year, this year House Bill 1011 and Senate Bill 1128 sought to move all licensing and vacation rentals to the state level, kind of taking that out of local municipalities' hands and saying, look, you can have your good neighbor ordinances in place. And so if there's a sound or noise violation or things like that, then sure, then you can regulate in that way to try to limit loud rentals, nuisances and things like that. But we're going to move all licensing for vacation rentals up to the state level and take it out of your hands. That, you know, died in the rules committee this year, but I think that you will see it come back. Airbnb, VRBO, these places have big lobbyists and a lot of money and a lot of power. So I think it's an issue we're going to see more of in the next legislative session.
Fascinating, especially the piece you spoke about with the property appraiser and homestead exemption. I have not heard that. That's you know, definitely something to keep an eye on. So
yeah, and maybe in these like older homes that have space below base flood elevation that is there, you know, legally, but it can kind of act as a separate apartment. That's counted in your square footage. And so a couple of examples I've seen is they've been rented out as vacation rentals, and property appraiser came in, had taken snapshots of these VRBO listings when they were available, when they weren't available, and used that to, Alan, prove that they were not used as just their home and their main residence, and carved out that portion in their homestead. So they didn't lose their homestead completely, but you would lose that percentage share. So say it was 25% of the house was below base flood elevation in this little apartment. They went back and kind of increased the taxes on however long they had owned it and been renting it out. So in many cases, 5-10 years, they were paying, you know, back taxes on what they had received homestead exemption for.
awesome. Thank you, Erin. Let's take it home with green space, something that I think is near and dear to a lot of people, you know, with all the growth going on. What steps are the city, what are they taking to ensure Sarasota is promoting green space, you know, thoughtfully, live work environment in the face of all of this explosive growth? What are your thoughts there, Erin?
Yeah, you know, I think this is something that the city did take very seriously back when they, you know, almost a decade ago when they were visiting Greenville, South Carolina, and trying to help plan downtown, creating shade trees, creating places where people wanted to walk and sit outside. And you see that now trying to kind of catch up in some of our other overlay districts. You know, the new Rosemary overlay district, which isn't even a year old yet, has required a lot more open space and things that would make it a more attractive place to walk downtown. For example, if a developer doesn't provide open space in its development, the new overlay requirements have that they have to provide and pay for open space fund, which will ostensibly be used to buy park space in the Rosemary district. The developer has to pay 0.5% of construction costs into that fund if they don't provide green space themselves in that new development. Other things that they're doing in the Rosemary district are requiring balconies to face the street, shaded front entrances, requiring architectural features every 80 feet on street facing facades so that, you know, you're not just on this blank white wall as you're walking down the street. So this is drastically different than what I think some people would have called the pro-development overlay that we saw a decade ago. And the reason that a lot of those buildings are in place in the Rosemary district right now was because of that former overlay district. We really haven't seen any new projects come online in the last year since this overlay, although there are some in the works. So I think that there's more to be seen on how that works and how this plan for the city is coming together to, to create some green space. Citywide, there's that, the public art new project, which requires 0.5% to be contributed to the public art fund or to place public art on the property itself. In the Rosemary district, it's actually an additional 0.5%. So just something interesting. I don't think many people have taken into account for the public art portion. All that said, I think that the DSCA Green Space Committee is working with the city to make sure the green space requirement, I mean, they are working so hard. I spoke with Patrick about this earlier, just to kind of get a sense with what's happening on the Green Space Committee. And some really thoughtful things are going on that committee level. So if you're interested, talk to Patrick and get involved. One thing that he was talking about is just the practical solutions in advocating for things as simple as shade trees instead of palm trees. So, developers may be putting up palm trees as part of their landscaping, but that really doesn't give you the shade that you will have. And it is so hard to walk down a sidewalk in Florida under only the shade of palm trees. So I think that is a really, and just one example that Patrick brought up of some of the thoughtful work that the Green Space Committee is doing. And I'd love to hear more as they meet with the city and move forward on some of this green space stuff, and just want to commend that committee on their thoughtful work.
Likewise, great point. Yeah, the DSA has just been so active. Actually, I cover St. Pete and Tampa as well in my role, and there's rumblings of, hey, what's going on with the condo associations in Sarasota, and so it's reverberating outside of Sarasota. So I couldn't agree with you more. Okay, so before we move to sponsors, we do want to have some Q&A time. So we've covered general condominium issues with Derrick. Alan covered construction defects and repairs, and Erin brought us up to speed on everything with land use and green space and traffic and all that. So 3 great panelists. Thank you so much. Let's go to some questions. We do have one in the queue. Let's see. I think this might go to Derrick. So it says, so verbatim, pandemic rules in hurricane shelters are problematic. What positions are taken if folks refuse to leave the building when ordered by EMS to evacuate? So I think what this is about is just how to enforce social distancing and with hurricane shelters. Derrick, any thoughts on that? Just want to acknowledge that question.
Okay, so are you asking me?
What positions are taken if folks refuse to leave the building when ordered by EMS to evacuate? So I guess condominium residents that do not want to leave the building because of the hurricane shelters not being safe. Again, this is verbatim, so I'm trying my best to.
So yeah, this is not that difficult. So basically, what I would say is when you're doing your emergency planning protocols and you're putting together your plan, you want to have a letter in there that can send you can e-blast to everybody, and basically it tells them, look, if the emergency operations center or the EMS or the police tell you that you have to vacate, and you choose to stay, you do so at your own risk and your own peril. And you know, there's nobody going to come for you. There's nobody going to help you, and we're not going to be liable for any damage or to you personally or your property. That way, it's kind of a catch-all, basically telling them you're on your own. And you know, unfortunately, this is not unfortunately, but this is America. People don't have to leave their homes, and you know, in today's day and age, with what's going on, you don't want to be involved with trying to get people out of their homes. That's not really your responsibility. You can call the authorities and ask them to try to force an evacuation, but that's likely not going to happen. But the association can just send out a mass letter and say, hey, look, you know, we're in an emergency situation. You got your ability to communicate through email. You send it out, and you go take care of yourself and make sure that you're safe. You know, then when you come back, if you know they're there, they might be maybe they're the first people you check on. But other than that, you can't really force people out of their homes.
Jake, I have something to offer on this.
Sure.
And it's really about the buildings, especially the high rises that were built in this area in the 70s and the 80s. The improvements to the Florida building code as far as building design and construction happened after Hurricane Andrew in the early 90s. And the engineers learned a lot of things through that storm and other storms. The building code for high rises were greatly enhanced. I know enough to know that buildings that were built, especially high rises in the 70s and 80s, are not safe. Most of them are not safe to reside in when you get probably much past a very minimal Category 1 storm. There's a few buildings that might pass muster. Many of them don't. They haven't been required to be upgraded. And the thing about concrete buildings is they don't get stronger over time. They actually get weaker. Reinforcing steel deteriorates. And so the buildings are vulnerable. So this is not a good place, especially in a high rise built in the 70s and 80s, to consider trying to ride out a storm. And also, if you're living in kind of a stick building near the coast, probably not a good idea either. So the owners need to understand that and heed the warning. They're not structures built 70s and 80s, not really meant to ride out a hurricane in.
Thank you, Alan. I'm not seeing any other questions in the queue. Did anyone else have a question for our most capable panel?
I have a question for Alan. Were you involved with the Dolphin Towers problem issue?
Yes, very much. I did the, I didn't handle the first party insurance claim, but I did handle the drafting the contracts with the engineer and the contractors. I did help somewhat with the first party claim, but yes, I know very much about Dolphin Towers.
They found a crack in the building, right? Everyone had to leave.
Well, what's called a transfer slab at the fourth floor started to fail, and there needed to be major reconstruction of that building. Interestingly, what the city required was not only that transfer slab got repaired, but actually the exterior walls be brought up to current code level. So Dolphin Towers, I don't think it's called that anymore. It may actually qualify as one of those buildings that may be able to withstand a significant storm because it had upgrades done to it during that repair process that brought it up, at least the exterior walls, up to current hurricane standards. unlike, frankly, many of its neighbors.
It's actually called the 101 Condominium, and I'm coming to you live from the lobby.
I should know, because I know somebody named Jim Toll, and I understand that he may be the president over there, and he also resides in the office down the hall, so I should know that.
Hi. Hello. I have
go
a
ahead.
question.
Sure,
Yeah,
go
I
ahead.
have a question. In talking about the green space that has been, it was discussed a little bit earlier, I have a concern, a question regarding that. We are in the downtown, and a new park, Thorpe Park, had just opened up. And we also have a green space down by the library, which is now encased in fencing. One of the things that we have noticed is the homeless, squatters, vagrants, unsheltered, taking space up in the park. And it seems as though that the green space is welcoming that. And I don't want to speak to the issues of the homeless, but what has been done for the city? I mean, it's great to make these parks, but they're not really meant for everyone. Right now, they're not being used by everyone because they're not usable by everyone. What do you know regarding ordinances, or what is the city doing to address those issues?
I'll only speak, I mean, I am not the resident expert on homelessness and the multifaceted approach to how that's being handled by the city and the county. I think there is a lot on the DSCA website about the number of different organizations and how they're approaching that. From a land use perspective, you know, that was the intent of, or one of the intents of having multi-use developments is, and Patrick kind of talked to me a lot about this as part of his passion project and something that he does, and just having more walkability on the streets, more presence passing these parks. Right now, because we're not seeing many of the commercial units filled, I think that is adding to the problem a little bit, although it was initially meant to kind of help with that problem and the walkability, and just kind of keeping fluid motion through these parks and past these parks. I think you're not seeing much of that right now, simply because the commercial spaces are currently unfilled. So that's all I can really add to that conversation. But I think, as we all know, it is a problem in Sarasota. It's being addressed on so many levels, starting at our large, you know, community foundations, through many different service options, through the city officials, through the police. So I am certainly not the expert to speak more on that.
Thank you so much for all the questions. Thank you, panelists. And we'll just remind everyone, you know, to contact our panelists if you do have any other questions.